hopefully everybody can both hear me and see the slide deck.
Yeah,
there.
perfect.
So Michael and I are going to talk about contract transparency in the minerals sector, and not just focus on what is often the theme of such presentations, which is what the negative connotations or aspects of contract transparency might be, or the opportunities that it gives for identifying and tackling corruption and criminal activity. We're actually going to flip that slightly and talk about, well, actually, what are the positives, and not just what are the positives for governments, but what are also the positives for businesses in the sector for contract transparency. So I suppose the starting point of that has to be the question as to what contract transparency is. And I suppose the first point to say is that it's about the public disclosure of bear with me just a second, my screen has just gone rather funny. Okay, right, I'm back with you. Is the public disclosure of contracts, licenses, and other similar documents that grant rights to extract minerals. So by that, in some jurisdictions, it will be a regime where the extractive sector is governed by contracts. In other jurisdictions, they may be more like a license regime or permits. And I appreciate we're talking about minerals here, but in the oil and gas sector, it could be things like production sharing agreements. So it's that whole range of contracts and legal documents which govern the extractive sector. Now, in some cases, that can also mean those which cover the exploration phase as well as the extraction phase. So it isn't necessarily just looking at agreements to do with that phase of the mining life cycle. It can be all the way through from permits to explore on a particular patch of land. And what does disclosure mean? Well, this is going beyond having something like a cadastre system, which is, broadly speaking, maps and names. This is about going into what are the actual full details on terms and conditions in those license agreements. So it's about the publication of the full texts of licenses. And again, here we're not just talking about the head level agreement, the one that sets out, which particular patch of ground is it that the license applies to, which particular minerals does it apply to, what's the duration and who are the parties, all of which is obviously very, very kind of interesting and vital information. What we're looking at here is transparency in the whole suite of documents that support that license. So that might include documents that set out environmental commitments that companies have made as part of the application and granting of a license. It may include social commitments. So that could be commitments around levels of local employment or local supply chain commitments. It could be commitments that have been made to build particular bits of infrastructure, whether that's roads, hospitals, schools, or whatever. So it's all those commitments that are attached to and which become contingent to the issuing and continuance of that license. It applies to contracts and licenses between governments and private companies. So what this doesn't extend to in the application that we're going to talk about is contracts or agreements between private sector companies. This is about the agreement between host government and the company which is in a position then to exploit those minerals or explore for those minerals. So that's what we mean by contract transparency. And in general, what we're talking about here is governments or government agencies having a source online where anybody can access all of the contracts that are in place in that jurisdiction. So that's kind of the concept. Why is it a hot topic at the moment? I guess there are a couple of reasons. The first is that there is ongoing advocacy from civil society organizations to understand the contract terms and obligations. And that's about as in so other areas of transparency, it's about holding governments to account as to whether or not the terms and conditions which are contingent to the issuing of those licenses are appropriate, but also holding companies to account as to whether they are fulfilling the obligations that are contingent to them having that license to operate. So it's part of shining a light of scrutiny on both the issuing of licenses and what terms and conditions governments are expecting companies to abide by, and also whether those companies are doing what's being said. We've talked a bit about EITI already today. EITI introduced a more stringent reporting requirement around contract transparency in its 2019 standard. What that requires is that the EITI implementing country should put in place a process whereby any license or contract which is issued or amended after 1 January 2021 should be available, publicly available, and there should also be a list of all previous contracts available so that you can see what contracts are in place. And EITI countries are busy implementing those requirements as we speak, and Michael and I can talk at length about the levels of application of that in EITI countries and where we've helped them on another time. There's also an ongoing trend towards more transparency in mining operations and company behavior. I mean, this is something that we've seen for 20 years or more in terms of scrutiny of companies in the mining sector, whether it's around their tax behavior, their corporate social responsibility, environmental impacts, and I suppose, most importantly, license to operate. And one of the key links in that license to operate chain is, well, what actually is it that businesses are having to commit to, and are they fulfilling those commitments? So that's kind of the landscape of contract transparency and what it means. I've already touched on the fact that there are jurisdictions which already have contract transparency regimes in place and are publishing large numbers of contracts. There are lots of EITI countries that are working towards publishing at least the newer contracts, and then over time that will mean that ultimately large numbers of contracts are in the public domain. But there are already contracts that are published. There are contracts that are published by governments. There are contracts that are published by the other party to the contract, the company. There are contracts which come into the public domain by other means, whatever that might be. And there is a central repository that is collecting and publishing those contracts already. And that is the resourcecontracts.org website. So what this organization, resourcecontracts.org, and Michael and I have no affiliation or connection with it. This is just for your information, as that it's a resource that's out there. What they do is collate contracts and licenses which are already in the public domain in one way or another, whether it's that the government's already publishing them, the company's already publishing them, or they are being published by a third party who isn't party to that contract. They collate them and just publish them without sort of making comment on them, but it is a repository of contracts. And there are a lot of contracts there. So if you look, this is as of this morning, there were 2,777 contracts publicly available on the Resource Contracts website. Now, I will point out that in some cases those are the model contract that is available in a country rather than the specific contract that applies to a particular license. But there are 98 countries covered across that website and 69 different types of mineral resources that are covered in terms of combinations and permutations. So contract transparency is moving forward, and it is an area that we think that businesses as well as governments need to start taking notice of. And that's not just the kind of knee-jerk reaction, which is contract transparency must have a commercial downside because we're having to disclose the terms and conditions which are in that agreement, but actually the opportunity that responsible businesses have from contract transparency. So I'll hand over to Michael now, who's going to talk a bit about what those implications for businesses are and what the opportunities are.
Thank you, Tim. And yes, there are, first of all, talk about some of the implications of this for mining companies. And as always, there are risks with this, but as Tim's already alluded to, there are some opportunities as well. And this is the kind of, and also some of the things to watch out for. So if you are a company operating in one of the 56 or so EITI implementing countries, and we've had 3 of them, as if by chance, in Sarah's carefully crafted agenda, we've had 3 of them speak today: Philippines, Ethiopia, and the DRC. Then you're likely maybe already to have been exposed to this. The EITI Secretariat in those countries should, not in all cases, should be working towards meeting this requirement from EITI and putting in, if it's not already in place, putting in place a system to publish at least those contracts that have come into force since the 1st of January 2021. And even if you're not in the whether you're in an EITI implemented country or not, there is likely to be pressure and growing pressure from civil society organizations to disclose contract terms, to understand in more detail what commitments you as a company have made, not just commercially, but in terms of technical commitments, but also, as you already said, in terms of environmental commitments, social commitments, and so forth. Now, there are one of the reactions to this, or one of the pushbacks on contract transparency, both from governments and some companies, is that you can't publish contracts because it would cause commercial damage. The terms are commercially confidential. In many countries, or in many contracts, there are obviously confidentiality provisions which prevent the disclosure of information under the contract. There may also be laws in place, and we've come across, even in countries which have Freedom of Information Acts, commercial information is often carved out as an exemption to Freedom of Information requests. So I'll come on to kind of specific actions in a minute, but for companies, it is a need to understand what terms you believe are really confidential and could really cause commercial damage, and others which, if everybody, if contracts are published and everybody knows information, then actually it might put everybody on a more even playing field and create a more functional and dynamic market. And now there are also some other risks around that. As Tim's just pointed out, the resourcecontracts.org website is basically a library. So contract texts are just published there without any context, without any narrative around them. And there's a risk that in EITI countries and other countries, as governments try to comply with this, they just, as it were, dump contracts online without any context, and maybe misinterpreted by those who want to, for whatever commercial or other reasons. So there is a risk that as a company, you get put on the back foot, you're under scrutiny, and you haven't had time to react. There's also, but there are opportunities here for companies, and companies who take maybe a more strategic approach to this. It is if contracts are published, or publishing contracts also provides an opportunity to show that you are meeting the terms and conditions of the contract, that you are doing what you committed to do when you signed the contract, that and maybe exposing where others, whether it's the government, other specific agencies, are not meeting their contractual terms, and therefore the reason why something may have gone wrong, or there may be an issue, is not because of something you've done, but maybe because of somebody else has done or not done. And therefore, when contract terms and obligations are in public, it's also an opportunity to influence the debate around contractual terms. Often the debate around, the contract terms aren't fair, they aren't equitable, and so forth, are done in an information vacuum where information about the actual contractual terms is not available to the public, and therefore, people end up speaking at cross purposes, asking for things which are either not realistic or may already be there in the contract, but just aren't implemented. So that's some of the implications for companies. Tim, if you could move on to the next slide. As a company, and this is aimed specifically at companies in the mining sector, what can you do about it? I think Sarah would be disappointed, maybe others on the call be disappointed if I didn't say undertake a risk assessment. But in all seriousness, you as a company do need to stand the risks about that. If a contract is put in the public domain, there will be information on price formulas, technical commitments, maybe production commitments, so forth, that will come into the public domain, and that may cause you real contractual harm or damage. So let's understand what terms you would really need to be kept under wraps and what can be made public. And there's been a lack of real debate and understanding about this. A lot of companies have not yet engaged with that kind of risk assessment, that kind of understanding, and really try to drive the debate about what can be made public and what shouldn't be made public. And often hiding behind a kind of, well, confidentiality provisions, or the law says we can't do this. The other action take is understand the implications and the impact on other, this is part obviously of a broader range of ESG issues, probably falls mainly within the G part of that, governance, how contracts are reached, what terms and conditions, how they're implemented, how they're monitored, and so forth. But will have an impact on environmental, social issues because of the commitments you make under those in the contract for those issues, and also maybe impact on other transparency issues as well. And so specific things for companies to think about is really develop a policy and approach to this, an engagement strategy, do engage on this. There is a real risk that a gap opens up and therefore a threat to your reputation between your actions and your words. We've already seen this in the ITI world when some of the companies that support the ITI, especially some of the bigger mining companies that support the ITI, they say they support the ITI, but they've been silent or haven't provided any support on kind of contract transparency or made any moves to support the implementation of contract transparency in countries where they're operating, and so opens themselves up to criticism and scrutiny about their contracts and their approach to this issue. And if you are operating in EITI, one of the 56 EITI implementing countries, understand what the current status of meeting the contract transparency requirements is, where the country's got to, and is there an opportunity here for you as a company to offer support, engage on this issue, and be part of the debate rather than kind of sitting outside it and let it kind of come and wash up on your shore. So I think with that, I will finish speaking and happy to answer questions.
Brilliant. Thank you so much for that, Michael and Tim. Massive round of applause for both of you. Absolutely brilliant. And I think it's always really interesting, isn't it, to, we've been talking about really tangible, on the ground aspects of mining and some of those environmental and those human rights aspects. And one of those themes that's really coming through from this session today is the need for transparency, not just so we can hold one another and ourselves to account, but so that we can understand perhaps what's going on there. Now, before I come to the main questions that are in the chat at the moment, the first most important question, perhaps, Michael, is that a dog that you have with you?
Yes, apologies for that. That is my dog Mocha. I will post a picture in the chat note. Sorry for that. She is extremely old. She's over 15 and a half now, and has taken to. So she makes a lot of noise when she gets up and about. And she's, for some reason, actually since the beginning of lockdown, she's taken to lying in this room. Apologies for that.
No, I have to say, Michael, your ability to carry on presenting during that is admirable, to be honest. So that's fantastic. Thank you for that. So everybody, the question has been answered. Was it a dog? was it something else in the room with Michael? We now know. So coming on to the more serious questions, perhaps, not that MoCA isn't serious, of course. So from Pauline, what happens with regards to EITI with longer term operations, which may be working to historic contracts?
Yeah, I mean, maybe I'll start on that, and Michael can then chip in. I think, as I said, the EITI standard requires new contracts to be disclosed, and it's interesting to think, why was that the decision that was made, rather than to say that all contracts need to be disclosed? I think part of that was an acknowledgement of the administrative burden that then might be placed on government agencies to switch from a position where there are large volumes of, in many cases, paper documents, which would then need to be transferred into or changed into an electronic format in order that they could then be placed online through a repository. You can argue whether or not that's a reasonable excuse, but I think that's part of the reason, and an expectation that over time, as new contracts come into force, those will become public. I suspect that in the fullness of time, there will be an expectation that the EITI implementing countries go back and fill in with those contracts which are still in existence, but which are older. But I think that the main reason why that approach was taken by EITI, I suspect, is to manage the administrative burden that there is in moving to having those documents online. But Michael may have some other views.
No, I think that's right. It's a balance between between kind of absolute transparency and practicality. So, for example, in countries where there's been a long history of mining, some of these documents and licenses may have been in place for hundreds of years, and there may be lots of them. So, for example, we've just done some work in Latin America, and in Mexico, there are 24,000 current mining licenses in place. So, publishing all those, putting all those online is the Mexicans are trying to do it, but it's a massive undertaking. Some of those licenses, as I say, have been in Mexico, which has a long history of mining. Some of those documents have been in place for over 100 years and have been amended, obviously, several times in that stage. So there's, and obviously, it's not beyond current technology to put all the kind of masses of documents online, but it does take time, effort, and resources.
Yeah, and particularly as sort of going back to the very start of our presentation, it's not just one agreement, potentially. It's potentially lots of sub-agreements that cover things like environmental commitments and employment commitments and those sorts of things. So it's not just a matter of kind of one per block, if you like. It's potentially then multiple agreements, and also quite a lot of background work to ascertain exactly which of those agreements are still relevant and therefore should be included, or which have been amended or superseded. So I think that's part of the challenge.
Great, thanks for that both. Ludovine, I know that you want to come in on this.
Thanks very much, gentlemen. Great presentation. I was wondering if you're getting a lot of feedback on, I would say, the ripple effect of this transparency. A lot of, the discussion that I've been hearing is about the fact that publishing all of these contracts really spotlights capacity issues and the imbalance of capacity between negotiating parties. So transparency would be step one, because it informs all stakeholders. But the next steps after that are to say, okay, what are we seeing in these contracts? What's the content, and are you seeing discussion arising from that?
I mean, I think just to sort of set the scene for that, maybe Michael could comment on that. But to set the scene, there are a range of different approaches in different jurisdictions. So some jurisdictions, the majority of the terms and conditions that govern the mining sector are set out in law, and the contracts are actually relatively light by design, because most of the terms are already set out in either in law or readily available public documents. In other jurisdictions, the law is very light, and the licenses or contracts are actually very heavy in terms of the terms and conditions and obligations on companies, and different countries sit in different places on that scale. And I don't think there isn't a right or wrong answer, and there isn't. It doesn't necessarily feed into the comment you're making directly in terms of whether countries that are where there is more of a disparity, you see them at one end of the scale or the other. I'm not sure. Obviously, to the extent that information is already in the public domain through legislation, then contract transparency becomes potentially slightly easier because there's less in there. In terms of that debate about disparity, I'm not sure I've seen it particularly. There's, contract transparency is still at quite a kind of nascent level. There are some jurisdictions that have done a lot in that space, and those are, in some cases, those are the ones that have got the sort of the better developed and longer history of the extractive sector. But in other jurisdictions, there's kind of very little being done. So I think at the moment we're still at the phase where jurisdictions are saying, what is it that we can put into the public domain, and what does that then mean? I haven't seen a huge amount. I think the use case for that information being in the public domain, like so many of these things, is that kind of phase. That next phase is, okay, that's great. How does that really get used, that information? Michael, do you have anything to?
Yeah, I think that's right. And building on from that, it's in a lot of cases an early stage, and in some cases these documents have only been available for maybe a matter of 2 or 3 years. And it also speaks to a comment in the chat about access to digital systems and access to communications. I think part of the next challenge is communicating what's in contracts, what are the implications of the contracts to the communities where it matters. And that is something that EITI is only, for example, is only just starting to do. And in some cases, kind of digital networks, communication networks are not as robust as they should be. Again, using the Latin American example, in the Dominican Republic, which puts all of its contracts online and they're all available. The problem is in the communities, in the mining sectors, the infrastructure just isn't there for communication. And also, these are big, complicated documents. So putting them in a format that you and me and others can understand. I mean, I spent over 12 years in the oil and gas sector. I still couldn't claim I understand the production sharing contract properly.
No, just by way of example, the front page of a contract, which was on one of our slides, which was an example from Mexico. I've just looked, that's 190 pages long. So I agree entirely with Michael. I think there is a real question about how you move from a place where, undoubtedly there are calls for contract transparency, and undoubtedly there are good reasons for it. But there's also a real challenge in moving from, Mexico has hundreds of contracts that are made public, and if they're all 190 pages long, dense legal text, that is not necessarily going to be particularly useful to local communities who are trying to understand whether or not the operation that's on the edge of their community is complying with the environmental commitments that it made when it was issued a license. Now, that doesn't mean that it isn't a stepping stone towards communities being able to achieve that, or for that company to be able to demonstrate that it is meeting the obligations that it signed up to. But it is only a stepping stone, and there's a real challenge there in moving from just putting information out there to having it in a format and being able to be distilled by users, including communities.
Brilliant. Thank you very much both for that. So what I'm hearing there is there's transparency, but there's also accessibility as well, in terms of actually being able to comprehend what on earth is said in those 193 pages or however many they were, for example, in the example contract that you cited there. So Michael, Tim and Mocha, thank you so much for your wonderful inputs to today's session. Absolutely brilliant. Thank you, guys.